Good evening to the aspirants of the All India Bar Examination, 17th Court, Karibusana. Welcome to my class. Anyone can unmute and read what I posted on the screen.
Law of Contract plus Specific Relief Act plus Law of Property plus Negotiable Instrument Act. Virtual MSQ test stars on 2/2/2023 ISC 9:10 p.m. to 10 p.m. from multiple law subjects. Professor Dr. Mohammed Saheb Hussain, Professor of Law, Saint Mounza, Tanzania, East Africa.
Thank you very much. All India Bar Examination, that is the 17th Court 2023 and the multiple choice question. Be ready to shoot. First question. According to Dash, I quote, the law of contract is the branch of law which determines the circumstances in which a promise shall be legally binding on the persons making it, I unquote. Said by or according to A. Mullah, B. Anson, C. Amir Ali, D. Woodrow Wolf.
Option B, sir.
The B for the Bombay, Anson is the right answer for the first question. Second question. There is an agreement between the X and Y that X will construct a house for Y and Y will pay rupees 10 lakhs to X. The agreement between A and B is a dash. Which is the correct option? Option 1, agreement. 2, contract. 3, it is enforceable by law. 4, it is not a contract. Options A, 1 plus 2 plus 3, B, 2 plus 3 plus 4, C, 2 plus 3, D, 1 plus 4.
A is right answer, sir. 1 plus 2
right
plus 3.
answer. 1 plus 2 plus 3 is right answer.
WRONG. Second option. Second option.
Two plus 3 is right answer.
2 plus 3 is the right answer. See, California is the right answer. The reason is there is no agreement. Actually, it is an agreement only. We don't say agreement is a contract, number 1. Number 2, it is enforceable by law because it is not illegal. And 4, it is not a contract. No, it is a contract. Hence, the right answer is 2 plus 3. Is it clear? Third question. It was held in this case that Mr. X promises to pay a monthly sum of £30 did not amount to a contract as there was no intention to create the legal relationship on part of either of the parties decided in the case of Dash. A. Cooper versus Cooper. B. Balfour versus Balfour. C. Kramer versus Kramer. D. William versus William. Shoot.
Cooper versus Cooper.
WRONG.
Right answer, sir. D for Delhi. William and William.
Read full. I say read
William versus
full.
William, sir. D is right answer.
Please
D is
read
right answer.
full.
William and
William versus William.
WRONG.
Sir, it's option B.
Option B, Balfour versus Balfour. It is a very classical case law. Fourth question. Classification of agreements. Find the odd man out. 1. Valid agreements. 2. Voidable agreements. 3. Enforceable agreements. D. Unenforceable agreements. Options. A. 1 plus 2 plus 3. B. 2 plus 3 plus 4. C. 1 plus 2 plus 4. D. 1 plus 3 plus 4. Shoot.
Option A, sir. 1 plus 2 plus 3.
WRONG.
Two plus three plus four is right answer, sir.
WRONG.
B.
1 plus 2 plus 4, 3 is right answer, sir.
It is C,
Option C,
California. 1 plus 2 plus 4 is the right answer. The reason is there is a valid agreement, there is a voidable agreements, there is a enforceable agreements. The host incorporated enforceable agreements. It is not there. Hence, the right answer is
1 plus
C is
2
right
plus 4.
1 plus 2 plus 4 is the right answer for the question. Fifth question. There are kinds of the promises. Which option is the correct option? 1. Express promise. 2. Implied promise. 3. Rational promise. 4. Substitute promise. Options. A. 1 plus 2. B. 2 plus 3. C. 3 plus 4. D. 1 plus 2 plus 3 plus 4. Shoot. There. Participants.
1 plus
Yes,
2 is
sir.
right answer, sir.
Answer A, sir. 1 plus 2.
Answer A. 1 plus
Answer A is the right answer. 1 plus 2 is the right answer. Because here I have given express
Answer
promise,
substitute.
implied promise, reciprocal promise, alternative promise. So there is no rational promise and there is no substitute promise. Hence, 1 plus 2 is the right answer for the fifth question. Now the sixth question. Mismatch the following, taking part A, the keywords and relevant section under part B. Part A, 1. Express promise, 2. Reciprocal promise, D. Alternative promise, 4. Consent. And part B sections, A. Section 9, B. Section 58, C. Section 2F, D. Section 13. Now, here options I have given here. A. 1 plus 2, B. 2 plus 3, C. 3 plus 4, D. 1 plus 4. Shoot the right answer. Mismatch, I said. What I said? Mismatch, I said.
Mismatch.
D, 1 plus 4.
WRONG.
C, sir. 3 plus 4.
C for California, 3 plus 4. WRONG.
A, sir.
C is right
Option A.
answer, sir. 2 plus 3.
If you say A, America A, 1 plus 2, WRONG.
B is right
2
answer,
plus
sir. 2
3.
plus 3.
B is 2 plus 3 is right answer because here I only changed BC means 2 3 I changed. The express promise section 9 as it is I kept it. Check here. And the consent section 13 I kept it here. Only I changed it topsy-turvy upside down, that is a 2 and 3, and hence it is a 2 and 3 the right answer for the sixth question. Now the seventh question. The court held that even if the defendant does not benefit from the promise he made for a charitable purpose, he is liable to pay the amount. He was responsible for his promise. A promise once made cannot be taken back after its commencement. It reaffirmed that the rule of law by stating that, I quote, any act done at the will of the promisors which is taken as the fulfillment of the consideration of the contract, I unquote, decided in the case of dash. A. Nath versus Hansraj Gupta and others. B. Commissioner of Income Tax versus Maharaja Dheeraj Sir Kameshwar. C. Kedarnath Bhattacharya versus Gori Muhammad. D. Commissioner of Income Tax versus Kameshwar Singh. Shoot now.
B is right answer, sir. Commissioner of Income Tax versus Maharaja Dheeraj Sir Kameshwar.
WRONG.
C is right answer, sir. Kedarnath Bhattacharya versus George Muhammad.
G.
The C is the right answer. That is the Kedarnath Bhattacharya versus Gori Muhammad, the right answer for the 7th question. 8th question, anyone can unmute and read?
Which one is not the types of contracts? A. Bilateral contracts. Number 2. Unilateral contracts. Number 3. Bilateral contract. Number 4. Multilateral contract. A option 1 plus 2 plus 3. B option 1 plus 2 plus 4. C option 1 plus 3 plus 4. D option 2 plus 3 plus 4.
D is right answer. 2 plus 3 plus 4.
WRONG.
Sir, option A plus 2 plus 3.
Option A, 1 plus 2 plus 3. There is the alliatory contract is there. There is a unilateral contract is there. There is a bilateral contract is there. But there is no multilateral contract because it is coined by the host. So there is a bilateral and unilateral contracts are there. Supplementary question. The best example for the unilateral contract and which case law it is? I repeat the question. The best example,
Bilateral or
unilateral contract. What is the classical case law in the law of contract?
Unilateral, sir.
I said unilateral contract. There is a classical case law is there. Supplementary question. What is the classical case law for the unilateral contract? Yes. For the unilateral contract, the best classical case law is Carlyle versus Carbolic Smoke Ball Company Limited. Is it clear? Carlyle versus Carbolic Smoke Ball Company Limited is the best example for the unilateral contract. I think you could not hear it. There is some problem of microphone. Yes, now you could hear it. The best example for unilateral contract is, the classical case law is Carlyle versus Carbolic Smoke Ball Company Limited. Is it clear?
Yes, sir.
Yes. The next question. 9th question. In this case, dash, it was held that display of goods along with the price tags merely amounts to invitation to trade, and therefore, if an intending buyer is willing to purchase the goods at the price mentioned on the tag, he makes an offer to buy the goods. Thus, the shopkeeper has the right to accept or reject the same. The contract would arise only when the offer is accepted. It is decided in the case law. A. Lasky versus Economic Grocery Stores. B. Chapelton versus Barry Urban District Council. C. Pharmaceutical Society of the Great Britain versus Brutes Cash Chemist Southern Limited. D. Fisher versus Bell.
Option A, sir.
WRONG.
Sir, D. Fisher versus Bell.
WRONG.
C is right answer, sir. Pharmaceutical
Grateful.
Society of Great Britain versus C is right answer. Pharmaceutical Society of Great Britain versus
Yes, C is the right answer. Pharmaceutical Society of the Great Britain versus Boots Cash Chemist Southern Limited. Supplementary question. What is the flick knife case law? It is also same. They put the tag on the flick knife, that is the button chalk, and they also say it is only invitation to sell. It doesn't mean that it is a sale. It is only the offer of the sale. Which case law it is? Supplementary question. I asked the supplementary question. If you know it, you tell me. If you don't know it, you say pass on. Did you understand the question?
Person, sir.
Did you understand the question first?
Yes, sir.
Yes,
It's
sir.
a flick knife case law. It's a very classical case law in the law of contract. Fisher versus Bell. A flick knife, button chalk, it's kept on the windows with a price tag. According to the Dangerous Weapons Act of the Britain, you are not supposed to keep it, and they filed a case against the owner. Owner says it is merely the invitation to sell. It is not a sale because it is not accepted by the other party, and hence it will not cover it. The same facts which is now I referred to the price tags, the same facts will be referred to the Fisher versus Bell. But the fact which I have shown is Pharmaceutical Society of the Great Britain versus Boots Cash, but not the Fisher versus Bell. So supplementary question they may ask in that way also. Agreed? Agreed?
Yes, sir.
Good.
Yes, sir.
Yes, sir.
Give the answer, otherwise I cannot move. 10th question. The guarantee should not be obtained through the misrepresenting facts to the surety, though not all facts need to be mentioned to him. Any facts that affect the surety's extent in the liability must be brought to his notice accurately. This can be seen in dash of the Indian Contract Act. Section 140, option A, option B, section 141, option C, 142, option D, 143. Shoot.
Section 143,
Sir,
right
option
answer.
Option B, section 141, sir.
143.
If you say section 143, WRONG,
B option is correct, sir. Section 141.
if you say B for
Section D.
Bombay, section 141, it is a WRONG.
Bombay.
The right option for this question is California C, section 142 is the right answer for the 10th question.
Okay.
For the 10th question, the right answer is section 142 of the Indian Contract Act. 11th question. Anyone can unmute and read?
In the case of dash highlighted, the court's discretion in granted the relief of specific performance has been discussed in previous cases as well. Specific performance can only be issued in exceptional cases. A. Yes, Gurumurthy died versus N. Raman. Option B. E. Shankar versus Sundaramurthy. Option C. R. Vinod Kumar versus M. Palaniswamy. Surender Kaur versus Bahadur Kaur Singh.
A, B, C, D is there.
Sir, option D, Surinder Kaur versus Bahadur Singh.
D. Surendra versus Surendra Murthy.
Yes, option D, D for Delhi, Surinder Kaur versus Bahadur Singh. In that case law, highlighted the court's discretion in granting the relief of the specific performance has been discussed in a previous case as well. Specific performance can only be issued in exceptional cases. It is decided in the case of Surinder Kaur versus Bahadur Singh. 12th question. Courts cannot suo motu grant refund of earnest money if it is not specifically prayed for in the specific performance suit decided in the case of dash. A. Rohtash Singh versus Deshraj. B. Shashid Bhatra versus Sudhir Rawal. C. Desh Raj versus Rohtash Singh. D. Fateh Chand versus Balakrishna Das.
Sir, option B, Sasit Basra versus Sudhir Raval.
WRONG. Second option.
Sir,
Sir,
D.
option A and C look like both are same, sir.
Balakrishnan Das.
I will give the answer, right answer. It is a C for California, Deshraj versus Rohtash Singh. That is the right answer for the 12th question. Is it clear?
Sir,
Okay, 13th question. Which was the latest amendment to the Specific Relief Act 1963? A. The Specific Relief Act Amendment Act of 2017. B. Specific Relief Amendment Act of 2018. C. The Specific Relief within parenthesis Amendment Act of 2019. D. The Specific Relief Amendment within parenthesis Act of 2020.
Option C is right answer. 2019.
WRONG.
Please write as
Option D, sir.
Option D.
Amendment Act.
The right
Option
answer
D.
for this question is B. The Specific Relief Amendment Act of 2018. 2018. It is the correct answer for the 13th question. Is it clear?
Yes, sir.
14th question.
Yes, sir.
The Indian jurisprudence has closely followed the English principle in this regard. The principle of dash are incorporated into the scheme of the Specific Relief Act of 1963. A. Fairness. B. Option morals. C. Option equity. D. Option justice.
Justice.
WRONG.
Equality.
WRONG.
Yes, sir.
sir, option A,
Fairness.
fairness.
The right answer is C. Equity.
Option
C for California. Equity. EQUITY. That is the right answer for the 14th question because the equity is immersed or incorporated in the Specific Relief Act of 1963. Now 15th question. In which chapter dash of the Specific Relief Act 1963 provides for a declaratory decrees under section 34 of the Act and is the present law which governs the declaratory relief in India? In which chapter it is there? A. Chapter 4. B. Option Chapter 5. C. Option Chapter 6. Option D. Chapter 7.
Chapter 6, sir.
Please
Option
answer,
C.
sir. Chapter 6.
C for California, Chapter 6, SIX6 is the right answer for the 15th question. Now 16th question. In suit for the specific performance of a contract, the plaintiff may also claim compensation for its breach either in the addition to or in substitution of such performance, and the options are goes A. Section 21 of the SRA. Option B. Section 21 capital B of SRA. Option C. Section 21 capital C of SRA. Option D. Section 21 capital D of SRA. Shoot.
Option A, sir.
WRONG.
Option C, sir.
WRONG.
Option D is correct, sir.
WRONG.
D is specific relief act. D is correct.
B for
The answer
Bombay.
is Bombay B. Section 21 capital B. Specific Relief Act. That is the right answer for the 16th question. Now the 17th question. Anyone can unmute and read? Those who read,
Transfer
can
of the
read.
Answer.
Transfer of the Property Act 1882. This act is central act and provides general principles of movable and immovable property such as sale, exchange, option 2 mortgage, lease and gift of property, option 3 part performance, option 4 wills and lease pendants, option A 1 plus 2 plus 3, option B 2 plus 3 plus 4, option C 3 plus 4, D 1 plus 2.
Should. Which was the appropriate answer among the ABCD?
Sir,
2 plus
option
3
D,
plus
1
4,
plus
sir.
2.
Option B.
If you
2
say
plus 3 plus
Delhi,
4.
option D, 1 plus 2, WRONG.
2 plus 3 plus 4, sir.
Why?
Mortgage, lease, gift of property is right, sir.
No. Answer again, you try once more.
2 plus 3 plus 4 is right answer.
Sir, option A, 1 plus 2 plus 3.
Option A, 1 plus 2 plus 3 is the right answer. The reason is sale and exchange is there, mortgage, lease and gift property is there, part performance is there, but list pendency is there in transfer of property, but not
Bills.
wills. Wills come under the, it would be covered by the act, may be called the Indian Succession Act, 1925
Yes, sir.
H, that is the clause, section 2, H will means the legal declaration of the intention of the testator with respect to his property which he desired to be carried into the effect after his death. So 18th question. Right such as the dash and the right to dispose of the waste among others are some exclusively legal right of the homeowner. Full stop. All three are correct but not one. Which one is not correct? Here, A, right of control, B, right of exclusion, C, right of disposition, D, right to have the property appraised in the fair manner. Should. Which one is the not connected with?
B is
Option
right
C,
of, right of exclusion.
disposition.
Say once again.
B is right answer, sir. Right of exclusion.
WRONG.
Right of disposition.
Option A, right of control.
If I agree, option A is the right answer. Why it is the right answer? Which is not connected. What will be the right word? It is a changed right of control. It is not right of control. It is the right of possession. Right of possession is the word which is connected with that, but I changed to right of control. So that is not connected to it. So wrong answer is right of control. Is it clear?
Yes, sir.
Yes, sir.
19th question.
Yes.
This is the primary legal paper that makes you the owner of the property you are buying. Therefore, you need to prepare the original copy of this paper and submit the same in the sub-registrar's office of your locality when you formally register the property. Options here are given. A, agreement to sale. B, sale deed. C, will deed. D, transfer deed. Which is the appropriate word for this corrected?
Answer B, sale deed.
Option B, sale deed, sir.
It is clearly a sale deed is the answer. That is the B is the right answer for the 19th question. Yes, anyone can unmute and read. Those who read, they should not read. 20th question.
How many
Yes,
sections are repealed under Specific Relief Act 1963? Option A 1, option B 2, option C 3, option D 4.
Option
C is
C,
right
sir.
answer, sir. 3.
3.
3, sir.
WRONG.
Sir, option B,
Sir.
2.
The right answer is option B, TWO2.
Option B, 2, sir. Yes, sir.
That is, the sections are repealed from the Specific Relief Act 1963. Now, 21st question. What are these two sections? A, 40 and 41. B, 41 and 42. C, 42 and 43. Option D, 43 and 44.
C is right answer, sir. 42 and 43.
WRONG.
Sir, option B, 41 and 42.
WRONG.
43 and 44, sir.
43 and 44, the last section of the Specific Relief Act 1963, it is repealed. The last section, here I will show you. Oh, it is not given. Specific Relief Act. I think I did not made it out. Okay. But for last sections are only the 43 and 44 of the Specific Relief Act. 22nd question. What is the Act ID number of the Negotiable Instrument Act? A. 1881-24, B. 1881-25, C. 1881-26, D. 1881-27.
Sir, option B, 188, 125.
WRONG.
Sir, option C, 1881-26.
Yes, it is the right answer. It is the Negotiable Instrument Act of 1881. The Act number is 26. Is it clear?
Yes, sir.
Now, next question. 23rd question. Which is the correct long title of the Negotiable Instrument Act? Option A. An act to define and amend the law relating to the promissory notes, bills of exchange and checks. Option B. An act to define and amend the law relating to the bills of exchange, promissory note and checks. Option C. An act to define and amend the law relating to the promissory checks, bills of exchange and notes. And option D. An act to describe and amend the law relating to the promissory notes, bill of exchange and checks. In the option
D, sir.
C, D, which one is the correct long
Option
title
D.
of the Negotiable Instrument Act?
Option D, correct, sir.
You want to say option D is correct?
Option
Yes,
A, sir.
WRONG.
Option A, sir.
Option A is correct. Because an act to define and amend the law relating to the promissory notes, bills of exchange and checks. Then what is wrong in the option B?
Instead of promissory note, you wrote bills of
I wrote the
exchange.
sequence changed. Instead of writing the promissory notes beginning, I wrote the bills of exchange. Later on, I wrote the promissory notes and checks. Then what is wrong in the C?
It is promissory notes.
Is the
but you wrote
promissory notes
Check,
not your
sir.
checks or bill or
Promissory
exchange
note, bill of
notes?
exchange and check.
Then what is the wrong identity in the D?
Described.
It said describe. It is not described. It is defined. So the right answer is
A is right, sir.
A is the right answer for the
Option
23rd
A.
question.
Option
24th
A.
question. Which section dash of NI Act is applicable or used in filing the cases of various courts in India? Option A 136, option B 137, option C 138, option D 139.
Option
A is right
C,
answer
sir.
for section 138. C for
Option
Kolkata,
C.
section 138.
138 section is mostly used in that. Now 25th question. What is the check bounce or dishonour of the checks under section which I have described below?
141. 141.
I did not
36,
mention the
A section
141 section here. I mentioned 136, 137, 138 and 139.
Option A, 136.
138, sir.
Lakshmi,
Option.
mute. I could hear your house dialects. Yes, please.
Sir, option A, 136.
C is
See, check bounce
the
cases
right answer.
comes under which one?
Sir, option A, 136 section.
Are you sure? I will show you. Negotiable
Act.
instruments. Where it is gone? In the negotiable instruments, I think I have downloaded this one. Negotiable instruments and oh, it's not there. See, section 138 of it, that deals with the dishonor of checks. Did you see it? Did you see it?
Yes, sir.
Yes, sir.
Yes, sir.
Why you are not giving the
138,
answer to
sir.
me? Read.
Yes. Section 138 of Act deals with
Section-
dishonor of checks, sir.
Yes. But how do you say 136? See here it clear. The dishonor of the checks under 138. According to section 138 of the Act, the dishonor of the checks is a criminal offense and is punishable with the imprisonment up to the 2 years or with the monetary penalty or with both. If payee decides to proceed illegally, then the drawer should be given a chance of repaying the check amount immediately. So these are the thing. And supplementary question, what is the section 31 of the Negotiable Instrument Act? It is a liability of the drawee of check. The drawee of a check having a sufficient funds of the drawer in his hand properly applicable to the payment of such check must pay the check when duly required to do so to do, and in default such a payment must compensate the drawer for any loss or damage caused by such default. How many characters are there in the negotiable instruments?
2, sir.
2.
Yes, sir.
Who are they? You say 2. Who are they?
Drawer and drawee and the bank. 3, sir.
Who is the beneficiary?
Roy.
Drawer.
See, a check, a person who writes is called
Drawer.
Dryer.
a person who receives the money is called.
Roy.
Dryer.
Then what is the bank?
Third person. There are three.
Surety, sir. Sure.
See, you say drawer, okay. Drawee also
Roy.
you can say. And what about the bank?
Payee.
The maker of a bill of exchange or check is called drawer. Agreed?
Yes, sir.
And a person thereby directed to pay is called the drawee. Agreed?
Yes, sir.
Then what is the bank?
Payee.
INN.
Yes?
The bank who pays payee, P-A-Y.
Yes. Bank is said to be, let us see whether PE or not.
Payer.
Payee bank account means in respect of each check presented for deposit using the e-check deposit service, the bank account of the payee of the e-check maintained with us into the which e-check is to be deposited, which may be sole name and joint name account of the payee. So payee bank. Is it clear? Here I have given C. If you are setting up your online bill payment for your checking account, the payee is the business you want to pay. Your utility provider, for example, providing the payee information tells us the bank who receives the money and where to send the check or electronic. So the payee is
Bank.
Drawer's bank.
it's
Drawer's
a bank
banker.
only. Yes, specific and future. Yeah. Specific Marriage Act. No, Specific Relief Act, I would like to make it out. This is Specific Relief Act, already there. So, let me check some of them. See, supplementary question. How many chapters and how many sections are there in the Negotiable Instrument Act?
Not audible, sir.
How many chapters and how many
17
sections?
chapters, sir.
Yes.
148 sections.
Repeat.
151 sections, sir.
Okay.
17 chapters, sir.
Yeah, now I downloading it. See, Negotiable Instrument Act 1881. See, chapter 1 is there. Did you see? I scroll down and I will show you where it ends. See, this is schedule enactment repealed. And there are, you said how many chapters? Did you see how many
17.
chapters are there?
17, sir.
17.
17 chapters are there. And sections?
51 sections.
148
151.
sections, sir.
151, sir.
But it is written 147 only here.
No,
sir,
151 is also
148
there, sir.
sections, sir.
See, this is the old act or new act? Now
Old
they are
act.
using 8081 only, is it not?
Yes, sir.
Yes. Then why it is showing 147 or something like that?
Sir, 2021 Act
What we are
recent Act
using
shows
now?
148.
What we are using now?
Act
151.
of 1881.
See, if you see it, they did not mention which act should have to be followed. What they say?
Sir,
Negotiable instrument.
the Bare Act mentioned 148 sections only, sir.
See here, Law of Contract, Special Relief, Property Law, Negotiable Instrument Act. Did they mention new act or old act? What is the new act number? Which year new act is? Negotiable Instrument Act.
2021.
2018, sir.
21.
Number 20.
Do you think that in the exams they do ask the 2021 act? Do you think
No.
that in exam do they ask 2021 act?
No,
No.
sir.
No, sir.
Why?
It is 1881 Act only, no, sir.
The answer is when the act will be implemented to teach after the 3 years only it could be asked the questions. Because
Yes, sir.
it is not retrospective effect. It is prospective effect. When it is prospective effect, in 2021 it is implemented, then the 3 years 21, 22, 23, 24, 24, 25 in the All India Bar Examination 25, they are supposed to ask it. At that instance, instead of keeping the confusion, they will mention the year. What we did under the Consumer Protection Act, I did not deal the questions in the 2019. I dealt the questions in the year
1986.
1986 only. Is it clear?
Okay, sir.
Yes, sir.
So, in that way that you have to deal the which act would be, for instance, only 4 instead of 44 central legislation, nearly 100 legislation of the state. In the labor law, we did not study only the 4 legislations. We study the old legislations only. Is it clear?
Okay, sir.
Yes, sir.
So the next class is,
Land Acquisition Act.
Land Acquisition Act, sir.
which is the last but one class. Which is a last but one class means
Intellectual property is last or last.
లాస్ట్ బట్ వన్ అంటే అర్థం చివరి కన్నా ముందర దాన్ని అంటారు లాస్ట్ బట్ వన్ అని.
Yes, sir.
దట్ ఈస్ ద లాస్ట్ బట్ వన్. సో వాట్ ఆర్ ద 4 types of the negotiable instruments? Answer is
Promissory note, bill of exchange, check, DD.
Now money orders are not there.
No.
No, sir.
Yes.
Promissory notes.
Promissory note, bill of exchange, check, DD, deposit, demand draft.
Yeah, there is an 1881 according to the Indian Negotiable Instrument Act of 1881, negotiable instruments can be anything that has a monetary value and are transferable. It enlists checks, exchange bills, and promissory notes, but excludes hundis and a common means of monetary transfer prevalent in some parts of India. So hundis will not covered under the Negotiable Instrument Act. Is it clear?
Yes, sir.
What are the 5 characteristics of the negotiable instrument? Number 1, must be in writing. Number 2, must be signed by the payer or maker, means drawer. Number 3, must be unconditional. Number 4, the specified amount must be defined, must be paid on demand or predetermined future date, must be paid to the payee. So when they want to see that the payee should have to receive the money, what do they do on the check?
Sign.
They cross and write it
You
as a
cross
payee on
it.
the top left.
We made the crossing again. Can you make the crossing to the right hand side corner? Can you make the crossing right hand side down? Can you make the crossing left hand down? Can you make the crossing at the left hand up?
Left hand up.
Answer is
Right hand up, sir.
No.
no.
Left hand up. Left hand up.
I will show you the even an image also. Cross check. Images.
Right hand upside, sir.
Check, see here. Did you see here?
Yes.
This is the right way. Amna kati kati. Did you see here?
Yes, sir.
What is written? Account payee. To the left hand upper corner. In the right hand generally, it's the payee, drawer, payer, signature is there. And always check should be numbered, dated, and you should be written both. You should be written both
Amount in
In
figures
amount and in numbers and words.
in a polished language,
Not in
the Professor Hussain language. It should be written in figures and words. Figures means Arabic numbers, cardinals, and words. Here we written in the cursor I have shown over here.
Yes, sir.
Can you read? Can you read who? What is the name?
Atul Watson. 10,000 only.
In figures,
10,000 only.
10, comma,
Rupees 10,000 only.
00 slash oblique virgule stroke hyphen. That is the style of writing. Is it clear?
Yes, sir.
Anything that is going to be asked? Still we have, of course I started late 10:10 no. Now the time is 10:10 India. 10:11 now. Am I right?
Yes, sir.
Yes, because and I did so many when videos are there under the negotiable instrument and the law of contract, even a specific relief act. Specifically, I dealt. Please listen those which are for the JCJ examination as well as PG PG set exam. I did it, and AP also that of course earlier JCJ TS also I did it, and you could see the many exclusively specific relief act, exclusively transfer property act, exclusively law of contract, exclusively negotiable instrument act. Please go through it for having the wide knowledge to make it out. But I have trained you in such a way, without knowing the answer, you can shoot the right answer now. Even though you don't know the answer, but you can shoot it now the right answer. But when I want to make it out, you know the reason of also. That is a very important factor. If you know the reason means you know everything. Is it clear?
Yes, sir.
Yes, with this, I would like to, tomorrow is the class for the same timings which I told you, and the topics are, what is the topic that?
Land acquisition.
Sir, land acquisition.
Land acquisition
It
act.
is a land acquisition act. We have to see it tomorrow. It's a 2 marks question, but doesn't matter, even a 1 mark, make it out. And the last class is intellectual property law. That will make it, with that we can sing a song, national anthem, Janagana Mana. So with this, I would like to stop with today's class, and Jai Hind.
Sir,
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
ख्वाब तक सिर्फ कश्मीर की आज़ादी के आते हैं।